Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, so let's go to Houston, home of the floods. I think it's flooding in Houston. This is a good example of a bread and butter fire department lawsuit, right? And it's I'll make it a little more general, even though it's in the city of Houston, right? But basically, the fire department responds to a person, puts the person in the stretcher, buckles the stretcher, is being careful. That's important. And then wheels the person down. The driveway changes grade, and the stretcher tips over.
And
this
she's
was an
94 years old.
Yeah. And instead of going to the regular hospital they're going to, they realize, okay, we should go to a trauma center appropriately. They head to the trauma center and the person never wakes up and dies. Look, I mean, your head's not cushioned in any way from these things that fall. But, you know, and not knocking the stretcher manufacturers, you know, when I was in EMS in 88 and then forward, we started with aluminum stretchers and they weighed like 30 pounds. And the only heavy thing to lift them was the patient. Now we have these auto lift stretchers, which is great for lifting, but they're like 100 and some odd pounds and they're awkward. You got the battery on one side, we got, you know, bags on another side. It's just awkward. And they're not, you know, they're not very wide, right? They don't really flare out because we don't have the room in the ambulance for them to do that. So they're narrow by design and they're tippy. I mean, that's just my experience, and they're heavy and they're awkward. So nonetheless, not this case, but maybe that was a reason. In any event, they sued, understandably, the city gets sued. And what the court basically holds is very common to a lot of states, right? Look, there's governmental immunity. You can't sue unless we say you can. Well, the government said you can sue in certain cases, such as if you violated a statute. Here, the plaintiff tried to say you violated a statute. The city was successful in saying we didn't do anything wrong and we didn't violate a statute. And the court said there's no jurisdiction for any court to hear this because there's immunity. So we're stealing the case and throwing it out. There's immunity. The governmental immunity protects you. You didn't violate a statute. And that's the end of it, right?
Well, and I think the other part here is that we're making an assumption that the level of fault on the part of the medics was at worst negligence.
Right.
And it was not gross negligence. It was not recklessness. It wasn't like they pushed the stretcher down a hill and were reckless.
And they strapped the person in, which is the reason we're covering that, right? They did attempt to act carefully, right? The gross negligence for most definitions means you didn't even attempt to act carefully. Negligence is you didn't act carefully, right? Much easier to prove. Here, maybe they didn't act carefully. But as you said, they certainly attempted to act carefully, and they certainly weren't reckless, right? Their conduct wasn't so likely to cause injury, it was almost intentional, the definition of recklessness or willful. And so that's, I agree, that would change. They did allege gross negligence.
And the court said it's not even close. It's
right.
At worst negligence.
Right. So when you try, I always use as an example that this would be a good example during the seatbelts. I always use an example of intubation, right? I intubated, I auscultated, but it went down the wrong tube. Okay, well, I attempted to be careful. I just got it wrong. I may have been negligent, but I wasn't grossly negligent. Immunity is going to keep applying.